Good morning. My name is Maxwell Glass. I'm the owner of the Glass Law Group, your Long Island traffic lawyers. Today, we're going to talk about distracted driving offenses. Distracted driving offenses in New York State are using a cell phone to talk on the phone or using any kind of portable electronic device, such as texting while driving or GPS devices, and using these while operating a motor vehicle. In New York State, the vehicle and traffic law under sections 1224 and 1225 codify violations of talking while using a cell phone or using a portable electronic device, such as the use of a text messaging device, respectively. In New York State, both of these offenses, 1224 and 1225, for using a cell phone or another portable electronic device, is a 5-point ticket which should be taken seriously. The cell phone ticket statute, that is VTL 1224, specifically addresses when a person is using a phone to talk while driving. So, for example, most commonly what happens is an officer observes a motorist on a highway or a public road either holding the phone to their ear like this or holding it like this. Now, many of our clients come to us and say, well, I wasn't using my phone, I was just holding it in my hand. I wasn't actually talking. This is a valid defense. What the law requires is that the officer, if the officer sees you holding the device like this, if it's in your hand even and it's far from your face, that creates a rebuttable presumption, meaning the presumption is by you holding your phone like this and the officer observes you, there's a presumption that you were using it. It becomes your job as a motorist to present evidence that you were not actually using the device. So to be clear, it's not necessarily a crime or an infraction, I should say, to hold your phone while driving. You have to be using it. The key to disproving use, though, because there is a presumption that you were using it, you need to present evidence that is admissible in court, such as a certified record that shows that you were not on your phone, you were not talking on the phone while driving. And you need to present that in a certified form as an official business record from your phone carrier, and that is one of the ways that we work with our clients at trial to fight for their right and to get the case dismissed. Now, that's for talking on the cell phone. The same rule of presumption applies for texting while driving, albeit there is a different statute that applies. For texting and driving, whether it be looking down at your phone or even if you're holding it out or even if it's on a device and you start touching the buttons, the rebuttable presumption is the same. However, the wording is a little bit different. There's still a presumption that by you holding the phone or pressing buttons that you were in fact using it to transmit, whether it's a text message, play music, check emails, some sort of an electronic method of transmitting information. That's what the statute says. There's that rebuttable presumption that you were using it. Again, it becomes the same thing. If you go to trial on it, it's your job as a motorist to prove that you weren't in fact using it, that even though you were holding it, it was not being used. And again, the same provisions that we talked about prior apply here. You need to provide a certified record from your phone provider, from your company, that shows that you were not using the device for the transmission of any data. So what we do is we look at the data part of your phone, whether it be your texting services, your music player, your GPS, and that all comes back on a certified record. And if it shows that, in fact, you were not using the device, you can then rebut the presumption, and it creates reasonable doubt. Remember, even for traffic infractions on Long Island, specifically, Nassau and Suffolk County, this does not apply to New York City. For Nassau and Suffolk County, however, the standard of proof to be convicted of a traffic offense is beyond a reasonable doubt. If you present evidence that is credible and admissible, meaning it is believable, and it also is admissible for a trial court, meaning that it is a certified business record, you can then admit that and possibly create the appearance of reasonable doubt as to whether or not you were using the device. I cannot emphasize enough how important it is that it's not just that you're holding the device, but to be convicted, they have to prove, they being the prosecutor, has to prove use. The problem for many of our clients, however, is that this is the rebuttable presumption, because there's a presumption of that when you're touching the phone, whether it be for texting or talking, that it was being used, and that's the hardest part of overcoming at a trial. Your attorneys, however, are aware of what needs to be presented in order for the court to consider evidence that rebuts the presumption. We know that we need to get certified business records from your phone carrier that shows that, first of all, that are signed off by a person at the company who maintains the records, and that show that your phone during the period, let's say, of 10 minutes before the stop and 10 minutes after, shows no data or no phone conversations whatsoever. It's a very serious ticket because 5 points is a significant amount of points on an offense. If you have any other questions, if you have specific questions, I should say, about a cell phone ticket or a texting while driving ticket, please contact us right away. We give free consultations, and it would be our pleasure to talk to you about your case and determine the best case forward. I really appreciate you giving me the opportunity to briefly overview you about cell phone and texting while driving tickets. And on that note, I ask everybody to continue to remain safe, healthy, and have a great day.